Yeah, what up, y'all? Welcome to Crown TV. I am the Crown Prince, aka Mr. Anti-Goofy. You know what not to do in my comments. Shout out to the Anti-Goofy gang. We approaching 10,000 strong. We in the building. If you want to donate to the channel and you really gang, instead of the super chat, hit up the Cash App gang. Alright, y'all. Today I want to talk about how the feds actually got Shotti's phone records. We know it's been famously said by Fubanga that Shotti is responsible for bringing the feds these phone records, and then that is what the feds used to threaten him with a superseding indictment. So today we're going to talk about that, and then we're going to talk about Bat being threatened with a superseding indictment in the same situation. And as always, we are going to do this within the paperwork, no speculation, no hypothesizing. Now, this is from a conference that happened on April 30th. The Fubanga interview was done on June 6th. So I just want that to be clear. And this is the judge talking to the federal prosecutor after the indictment had been changed and the 5 people who had already pled had been removed and new charges had been added. Now the judge says, turning to the discovery, let me begin by asking the government to put on the record any new discovery that it has come into possession of since the February 27th conference. The prosecutor says, yes, thank you, Your Honor. As the court is aware, throughout these conferences and throughout this process, we've been representing that there are certain phones that we've been waiting to get into that were with a third-party provider. We were able to get into one of those phones. The phone belonged to Kafano Jordan, who we all know as Shotti. So that phone has been produced to all defendants. I should say the contents of that phone. The judge asks, how voluminous is that? The prosecutor says, I believe it was about 91 gigabytes. So this is a phone that Shotti apparently had for a long time, and it had a lot of information in it. The court asks, that was produced when? The prosecutor says it was early April, Your Honor. I believe it was the day after he pled guilty, which I have on my notes here. He pled on March 28th. So it was a day or so after he pled guilty. The judge says, thank you. Where are you on the other phones? The prosecutor says, still waiting. The judge says, waiting because the authorities have been unable to start work getting into the phones, or because they're working but unsuccessful. The prosecutor says the algorithm is working itself, and so it's just a time issue. We may not get into it. It's just one of those things where if the algorithm cracks the code, so to speak, then the judge interrupts. The judge says, I take it that there is some finite number of combinations. I mean, I don't know how all of this works, but there's some end to the process. Do you have a sense when you know whether you have been successful? The prosecutor says this phone we got into was, I can't remember if it was sent off in May or July, but it took until the end of March to get into it. So that gave us some kind of idea how long. But again, the vendor, it could still take longer, Your Honor. The judge says, sorry, it was May or July. That was before the indictment here. The federal prosecutor says, correct. As I stand here right now, I can't remember when the phone was sent to the provider, if it was in May or in July. The judge says, but that would have been sent before the case was indicted here. The prosecutor says, correct. It was during as we were investigating. We got the warrant before we indicted. The judge says, I see. The federal prosecutor says, we sent it to the provider before we indicted, but we couldn't get it until March. The judge says, all right, look, I have no idea how consequential or voluminous the contents of the other phones will be, but as we get closer to trial, the argument would become stronger to use the contents of the phone depending, again, on a whole host of issues that might or might not present issues of fairness. So it's in your interest to expedite the process to make sure that there isn't a claim that the timing of the eventual production compromised somebody's trial rights. Now this is where we get into Bat's issue, and I also have some separate Bat paperwork that we're going to go into. The prosecutor says, understood, Your Honor, there were cell site records that we provided. This related to January 19, 2018 shooting in which the government contends that Mr. Young was the shooter. Mr. Young has now since pled guilty. The judge says, and you obtained cell site records of whose phone? The prosecutor says Mr. Young's phone. The prosecutor says, again, Your Honor, I think it was mid-April, and then he says shortly before his plea. All right, so let's recap real quick. Fubanga's story is predicated on the fact that Shotti bought the feds these phone records, and then based on the phone records, he was threatened with a superseding indictment. What you have here in black and white is proof that Shotti never bought the feds those phone records. In fact, they had to get a warrant for it. This is the warrant that they got last July before anybody was even arrested. This is during the investigation. Again, this is not something that Shotti gave them willingly. They had to get a warrant for it. And not only that, Fubanga was not the only one approached with these newfound phone records. They gave them to all of the defendants. If Shotti did not provide the feds with these phone records, which he clearly did not, then Fubanga's whole entire story falls apart at that point. Now, I'm positive that there were things in that phone that not only incriminated Fubanga for them to threaten him with a superseding indictment, but it probably was things in there that incriminated a lot of people, and a lot of people probably got threatened with superseding indictments. But because it was Shotti's phone records specifically, and there was the threat of the superseding indictment, I think Fubanga jumped the gun and accused Shotti of snitching based on him bringing the feds these phone records, which he clearly did not do. Now, I'm going to show you how this same exact thing happened to Bat. Bat's phone was one of the phones that they were trying to get into, and they got into it at the same time they got into Shotti's phone. They also threatened Bat with a superseding indictment, telling him to plead to what they already had him on, or he was going to get wrapped up in this superseding indictment that was coming. Bat got a chance to have his lawyer question the judge on this, and it's an interesting conversation, so we're going to run through it real quick. Now, this is a conference that was held for Bat, and the only thing I want to show y'all on this first page is kind of an outline of what's happening at this conference. This is the judge talking to Bat's lawyer, and he says, good afternoon to you, whatever the lawyer's name is, and he says, good afternoon to you, Mr. Young, who is Bat. You may be seated. He says, I have been informed that your client intends to plead guilty today to count one of the indictment. Is that correct? The lawyer says, yes, Your Honor. He indicated that to me earlier this week. He has some last questions which could affect whether or not he goes through with the plea. He wanted to ask those questions of the court because he felt like some of the questions I gave him, in his words, don't really make sense based on what he thinks would make sense, based on past experiences with the criminal justice system, and also just based on his own sort of common sense about it. So here you have a conference that was called for Bat to discuss some things that was going on in his case that he didn't understand. He asked two questions, and I'm going to skip to the second question because that's the one that's relevant to what we're talking about. His lawyer says, so one of the other concepts he's struggling with, Your Honor, is that the government can say to him, here's an offer. If you don't take this offer, you should know that a superseding indictment is coming that's going to change your mandatory minimum. And that superseding indictment is going to include other things that are not charged in the current indictment, even though you've been here facing that indictment for several months. The judge says, right. The lawyer says, so he's struggling to understand how that's possible. The judge says, Mr. Warren, remind me of the schedule of the case, what I have said and authorized in terms of the date for a superseding indictment. Mr. Warren says, I can't recall if Your Honor gave a firm date for a superseding indictment off the top of my head. I know Your Honor had mentioned it, I believe, at the first conference. I believe Your Honor had said months in advance of the trial. I don't remember off the top of my head a specific date. The judge says, my memory is that I gave a date or a general time period, but with leave to go beyond it for good cause. I just don't remember what the date was. In any event, Mr. Young, Without commenting on the facts of this case, what I can say is as follows. The government is at liberty to disclose to you what its intentions would be if there is not a guilty plea. If there's a guilty plea, it appears to me from the draft agreement that has been provided to me that the government would be agreeing to forego additional charges in connection with the 9 Trey Gangster Bloods if you plead guilty to the crime in question. But apparently the government is saying if you don't plead guilty, they will add charges against you. I have no idea what the facts are here, and I have no idea what the government's evidence is. But the government is allowed to do what it's stating to you it's going to do. It's allowed to share with you its intention so that as you decide whether or not to plead guilty, you are aware of what the government will do if you don't plead guilty. As your lawyer is saying, what the government is apparently representing is that they will try to obtain a superseding indictment. They can't simply charge you. They will have to go to a grand jury, and the grand jury has to vote to charge you with that crime, just like the grand jury has voted to charge you with the crime in count 1 of the present indictment. Now, we know from the previous document that the basis for this superseding indictment was that these phones had been cracked and they had gotten the information out of them. So here you have Fullbanger and Bat in the same boat. These phones have been cracked, they got the information out of them, and now they're threatening both of them with superseding indictments, which the judge is telling you clearly that is how this thing works. What happened to Fullbanger was not something foreign, or he was not a special case. They went to other defendants in the same case and did the same exact thing once this information became available. Not by somebody bringing in phone records, but by them cracking the phones and getting the information themselves that was obtained with a warrant. But in the end, the only thing that matters is what y'all think. So let me know what y'all think about this in the comments. Like, comment, subscribe if you are not a goofy. If you are a goofy, you know the rules. It's the Crown Prince. I'm out, y'all.